This is Scott Pierce. Today's seminar covers corporations, and once again, we are dealing with relatively simple material. The corporation's black letter law that we are subject to being tested on is not terribly complicated, and there isn't that much of it. Still, it's useful to think of corporations as being the bar examiner's latest excuse for testing torts and contracts and especially remedies. Remedies issues are going to come up over and over again here in corporations, and I will show you exactly how that is very shortly. Let's take a brief look at the approach that I have presented to corporations. Here, this approach is going to focus principally on that body of law that is special for corporations. But keep in mind, in the background, torts, contracts, and the law of agency all are being tested here, as well as fiduciary responsibilities. Here, as is the case in professional responsibility and in the law of wills and trusts, we are going to find fiduciaries doing what they always seem to do on bar examinations: steal, cheat, lie, and self-deal. And we're going to be asked to discuss the rights and remedies of various aggrieved parties who will claim to have had violations of their rights made by fiduciaries that were in a position of trust. So as we look at the approach, you'll see that I have organized it according to the life cycle of the corporation. We basically talk about birth, life, and death, and then consider remedies. And you'll see that I have tucked in securities law issues wherever they arise, rather than dealing with them in a separate category. So we look at the birth of a corporation, the organization of an entity, and we see that there are a series of issues dealing with the actual process of incorporation, the actions of promoters before the corporation is formed, and defects in corporate papers, and the consequent possible change in the rights and remedies available to different parties. Also, we deal with piercing the corporate veil here in order to attach liability to individuals who don't deserve the protections accorded by the corporate veil. Next, as we organize a corporation, this is a useful time to consider corporate financing. And whenever we get a company that is seeking access to the public capital markets, the securities regulations are relevant and they come into play. Here, the primary sale of shares is at issue in corporate organization, and this part of corporations law is inherently crossed over into the law of contracts. And so we will deal with those issues in a fair amount of depth. But with regard to securities law, let me just give you the big picture up front. For the bar exam, basically what we are being tested on is the duty to disclose and the anti-fraud and anti-insider trading provisions of the securities laws. This area of law can be enormously complicated, and in fact, as one who has been a professor of securities law, I can tell you that this is extremely interesting as well. But for the bar exam, they're keeping it very simple. You don't need to have a separate background in securities law. And in fact, to the extent that you are already a specialist, it might really be a handicap. Because here what they're looking for is basically minimal proficiency and a certain glib familiarity with the various terms. So, with regard to the subscription agreement, keep in mind that the elements of a basic contract analysis, offer acceptance consideration, etc., are relevant, and also 10b-5, the anti-fraud provisions, also are relevant here. Next, we consider the operation and management of a corporation. Here, we spend a lot of time dealing with the different players in corporate business, and that includes the directors, the officers, and the shareholders. And it's important to understand the different rights and the different responsibilities that each of these three different categories of player involve. So, directors and officers are fiduciaries. Typically, shareholders are not. But if we have a shareholder with a big enough stake in the company, that will give a big shareholder some fiduciary responsibilities. And we'll see how that plays out in the not too distant future. With regard to shareholders, here the big issues are proxy voting, representation of minority shareholder interests, and most commonly, derivative actions. Keep in mind that plaintiffs in corporations questions can have two different broad categories that their theories of liability can arise under. First, and perhaps most commonly, we will deal with shareholders suing as individuals seeking to obtain remedies based on theories of liability arising out of contracts and torts primarily, but also to some limited extent arising out of corporations law or even real property. Also, we can have liability arising out of contracts for breach, and we'll have shareholders seeking damages, restitution, or equity in their individual capacity. Now, the second broad category is derivative actions, where a shareholder is acting on behalf of the corporation, seeking remedies not for himself or herself, but for the entity. And we'll see how that looks in bar exam essay questions as well. In the operation and management of a corporation, here I choose to consider the secondary sale of shares, the regulations that relate to the trading in stock that already has been issued by the company. And here, again, we focus on directors, officers, and sometimes on controlling shareholders. 10b-5 contains the basic anti-fraud provisions, and remember that 10b-5 breaks down into elements just like negligence breaks down into elements. The elements of Rule 10b-5 include materiality, reliance, scienter, and interstate commerce. And this idea of materiality is really an interesting one. And in securities law class, we spend an awful lot of time talking about what information is material. And there's a lot of interesting case law on the topic. But the bottom line is, information will be deemed material if, in the total mix of information available to the public, that information would be relevant to a reasonable investor's decision in deciding whether or not to engage in investment activity. So, as we do this analysis, we will focus on the identity of the plaintiff and of the defendant, and then we will go into the elements of the cause of action. Now, the other numbered rule that we need to know for bar exam essay purposes in corporations exams is Rule 16b. What Rule 16b focuses on is insider trading involving short swing profits. So, here again, we have to establish the insider's status, and then we are looking at the defendant, obviously. Then we describe the short swing profit. This is always an exercise in analyzing the facts. Then, finally, we consider dividends and the repurchase of shares. And more commonly than not, these issues arise where we have a shareholder who is seeking a dividend to be compelled, or where someone is seeking to set aside a dividend as being ultra-virus, or another act that displays a breach of fiduciary duties owed to the corporation. Next, we deal with the organization and winding up of corporate business. Here, this also can include mergers and acquisitions, another enormously interesting area of law in the real world. On the bar exam, it's tested in very straightforward, simple ways. Then, finally, we consider the distribution at the time of dissolution of the corporation, and that wraps up the basic body of law that arises out of the law of corporations. Finally, we turn to remedies again. Keep in mind my view that remedies is omnipresent on this exam. You can have remedies issues anytime you've got civil litigants. And since almost no corporations law involves the law of criminal law and procedure, then we must be concerned about civil remedies. Remember what they are: damages, restitution, and equitable relief. And keep in mind that there can be government plaintiffs as well as private plaintiffs in corporations lawsuits. The SEC, the Securities Exchange Commission, can pursue civil remedies as a plaintiff. They also can involve the Justice Department and the Attorney General of the United States for criminal prosecutions. And, as we all know, over the last 10 or 15 years, the corporate scandals have been severe enough that even a Republican administration, with both houses of Congress controlled by the Republican Party, have passed laws that extend the criminalizations of certain forms of corporate misconduct. So, that's the picture, and that's the approach to corporations. We take a step back, consider, again, the basic approach to civil litigation. A plaintiff must have one or more theories of liability. These theories can be broken down into elements, and that's as true here in the law of corporations as it is anywhere. Also, the plaintiff will have a prayer for relief, remedies that they want, and these will arise out of damages, restitution, or some form of equitable relief.